before the opening line. At a Senate hearing, this Senate hearing starts with a legal question, but very quickly turns into something much bigger. Race, voting rights, partisan power, Supreme Court authority, and the future of American elections. What begins as a discussion about congressional maps becomes a full political clash over who gets represented, who gets blamed, and who controls the rules of democracy. Stay with this, because the biggest moments are not just in the answers. They are in the framing, the interruptions, the reversals, and the explosive personal exchange at the end.
Future of voting rights protections. Watch the biggest moments from the heated hearing right here.
You heard accusations from some that the Callais decision guts the Voting Rights Act. Is that accurate in your mind, and could you explain why you think it one way or another?
Absolutely not, Mr. Chairman. Callais brings the Voting Rights Act back to the plain text of the law that was actually passed at the amendment in 1982.
After Callais brings the Voting Rights Act back to the plain text. Here, the witness is making a very specific legal argument. He is not saying voting discrimination cannot exist. He is saying the court decision limits how Section 2 of the Voting Rights Act can be used, especially when race becomes the central tool in drawing districts. That distinction matters. Supporters will call this constitutional clarity. Critics will call it a rollback of civil rights enforcement. So the real question for viewers is this. Is this a correction of legal overreach, or does it weaken protections that still matter today?
To read the Voting Rights Act any other way is to either make it meaningless or make it unconstitutional and make it fail to be congruent and proportional to the 15th Amendment. I mean, the law itself says that we can't have proportional representation. That can't be a goal. It's not a constitutionally permissible goal. That was part of the compromise. And so all that's going to happen is we're going to be able to still meet the goals of Congress when that was passed. Instead of strict, you might say clear and convincing proof of intent, the standard that really that law brought from earlier case law, which is, I would say, an objectively, objective evidence of intent, even though it may be circumstantial, that can still establish a Section 2 claim. And if that conduct is still happening, you can still bring a Section 2 claim. I mean, you could bring a racial gerrymandering claim. You could bring a vote dilution claim under the 14th Amendment directly or under the 15th Amendment without using Section 2. So there are all kinds of ways to combat discrimination. What we're losing is sort of the rough proportionality that Section 2 had gone into, and that's not losing anything. In fact, what we're losing is the very thing that caused racial gerrymandering to occur.
Thanks. Mr. Chamberlain, I want to ask you, I want to talk about California just for a minute, the California map, because you referenced the quote. I had it in my opening statement. There's evidence.
Thanks, Mr. Chamberlain, I want to ask you. Now, the hearing shifts from legal theory to real-world maps, and that is where the political temperature rises. California becomes the example because the senator is focusing on whether mapmakers openly considered race when drawing districts. This is a classic hearing tactic. Move from abstract law to a concrete case, then force the witness to say whether that map is vulnerable. Notice the strategy here. If the witness agrees, it turns one court ruling into a possible roadmap for challenging multiple states.
Quotes. This is that the map makers have talked openly about specifically creating a district based on race. Do you feel like now that's a vulnerable map?
Absolutely. Obviously, if you use race intentionally, and you have statements like that triggers strict scrutiny. And that's exactly the kind of thing that our Constitution says is odious. We should not be just bean counting and putting people into districts based on what race they are.
And I'll move now to Illinois, because I've written this letter to Ramit Dillon. I think these are the two most obvious examples, California, Illinois. There are more. Mm-hmm. There are more, and I hope that they're very aggressive about this. If we're serious about getting rid of making race the reason why you're creating a particular map, which is inherently discriminatory, then DOJ has a very important role here. In Illinois, the law requires consideration, in the statute, requires consideration of crossover district, coalition districts, and influence district based on race and language minority status. Does that kind of law tell map makers to think about racial categories from the beginning?
Yeah, that's exactly what it does. And again, under Callais, that's certainly not going to be constitutional. And it's also, when people say that the Voting Rights Act has been destroyed, not so. The Voting Rights Act is still there. What this means is that this is probably a violation of the Voting Rights Act, because the Voting Rights Act is now aligned with our Constitution.
Is there something that is just a little fishy about the legislature coming up with a map where 40% of the people who in that state may be African American end up where districts are designed that have the effect of meaning there's no black representative?
Well, a couple of answers. First, the black voting age population is much less than 40%. It looks to be about 31%. But the other issue is
31% and zero. I'm just asking
sure.
on the smell test, okay?
No, I think you have to know where the voters live. I mean,
the people writing the maps know exactly where they live. That's the whole point.
Well, the point though is that we're not assigning seats based on race. We're actually drawing geographic districts.
But we are assigning seats, you can dispute this if you want, by the writers of the legislation. And by the way, this is true in Louisiana, it's true in California, on the judgment of those legislators, the majority, about where they can get the most votes. Isn't that right?
Well, I mean, that's right, but that's our point, is that these are political considerations.
Right, so what you're saying is you're full on board with partisan gerrymandering.
Well, the Supreme Court has made clear that that's not a positional claim. Right.
I am asking you.
Right.
You are on.
After. So what you're saying is you're full on board with partisan gerrymandering. This is one of the sharpest turns in the hearing. The senator moves away from racial gerrymandering and reframes the debate around partisan gerrymandering. That is politically powerful because it exposes a tension. If race-based districting is constitutionally suspect, what about maps drawn mainly to protect party power? The witness answers like a lawyer, but the senator is asking like a voter. And that contrast creates the drama. What is legal may still feel deeply undemocratic.
On board, you think it is okay in this country that partisanship be the exclusive judgment upon which a majority in a legislature will design the districts in that state?
What I'm okay with is the Constitution actually gives this power to state legislatures.
Okay,
that's the Constitution.
I'm not asking you the lawyer question here. I'm asking you the citizen question. You know, a democracy, there's a tug of war. And would you dispute my point that when you have the majority in a legislature, and pick your legislature, a Democratic California, a Republican Louisiana, and those legislators on whatever it is, the Rules Committee, go in the back room, they go over the maps, they go over the computer projections, and they have one goal, and that is to make certain that the maximum number of R's or D's get elected. You're okay with that?
Well, as a citizen and as a lawyer, I understand that's actually the system that we have. That's actually what the Constitution says, and if we want to change that...
And what's happened with that is we have a race to the bottom now. And you heard me suggest to my chairman, who I think is a tremendous colleague, that we ought to be having a battle over ideas as opposed to picking the voters that we want to vote for us. You have a problem with that?
No, my problem is the Constitution.
Do you have a problem with that? Look, I am asking as a citizen. We are now in this total race to the bottom where legislators are doing, we're going to be doing redistricting every 2 years. We're going to be doing that. In every state, if there's a change in the legislature, they're going to be doing the same thing. Isn't it time to get rid of partisan redistricting? And isn't it time, gerrymandering, and isn't it time to stop the every 2 year cycle of redistricting?
The genius of our country, of our Constitution, is that we allow the political branches to fail. We allow them to sometimes hit the bottom, and then they pay the price at the polls. And that's what should happen.
The Supreme Court just interfered with the decision that this Congress made.
We had all kinds of ways to keep black people from voting. We had poll taxes. We had literacy.
Before, the Supreme Court just interfered with the decision. Here, the argument becomes historical and emotional. The senator is not just debating one case. She is tying the court's decision to America's long record of voter suppression. Poll taxes, literacy tests, intimidation, and other barriers used to keep black citizens from voting. This is a deliberate appeal to memory and accountability. The message is clear. Voting rights law did not appear out of nowhere. It came from a history of exclusion. The question is whether today's court is respecting that history or minimizing it.
Tests. We had, I think they, some places even required them to count how many jelly beans were in a jar. All kinds of ways to keep black people from voting. This happened. I don't think anybody can deny that that was going on. And as far as I'm concerned, there is a pattern now of voter suppression going on in our country right now. And the Callais decision just plays into that by pretty much gutting the Voting Rights Act, which, by the way, was reaffirmed many times in a bipartisan way in acknowledging that this kind of racial discrimination occurred and that as a democratic country where everybody has an equal vote, that's not tolerable. But suddenly it's A-OK just because the Supreme Court says so. No, it's not the entire Supreme Court. It's a 63 majority, which I consider to be basically an out-of-control Supreme Court majority where there is a pattern of this kind of decisions out of this court. So just because this court says so doesn't mean I agree with them. So meanwhile, there is voter suppression going on. You have an attorney general who sued at least 29 states to get these states to turn over their voter rolls. Why? What does the Department of Justice, what does the executive branch want to do with all this voter information? Up to no good, I would say. There's this huge push to pass the SAVE Act. It's more Save Trump Act. And what does that act do? It would require...
Before, there's this huge push to pass the SAVE Act. This section introduces a major political claim that new proof-of-citizenship voting requirements could make registration harder for millions of people. The senator's argument is not just about what the law says on paper, but how it works in practice. Birth certificates, passports, name changes after marriage. These details can become real barriers. Supporters may call such measures election security. Critics call them voter suppression. So viewers should ask, where is the line between protecting elections and making voting unnecessarily difficult?
Millions and millions, all of us who are registered to vote, suddenly we will have to show proof of citizenship, either through a birth certificate or a passport. Millions of people don't have either. Married people who take their partner's name will not have a name that matches their birth certificate. So what are they going to do? There are going to be millions of people who are not even going to register to vote. And you think Trump doesn't know that? Of course he does. That's why he wants the SAVE Act to be enacted. That's why the Republicans would like to see the SAVE Act enacted, because they know that millions of people will be literally disenfranchised by not even being able to allow to vote. And then with this regime, once you do vote, they will challenge your vote as they did in the last elections. So voter suppression is going on. It's very reminiscent to the kind of stuff that was going on that the Voting Rights Act was intended to address, to fix. And now you have a Supreme Court that says, oh, never mind all of that, never mind all of that history. And over 3 cases, they succeeded in gutting the Voting Rights Act. And don't tell me that the provisions of the Voting Rights Act still exist in a way that is pretty much unenforceable, because the racial gerrymandering is going to be okay unless the legislative body that does the gerrymandering says, oh, by the way, we intend to racially discriminate. Are you crazy? You think that state legislators are going to be that overt about it? Of course not. So you have a Voting Rights Act that you claim is still intact. Please, give me a break. I have a question for Mr. Cox. Last weekend, thousands of people, and apparently you were among them, gathered to protest the Supreme Court's gutting of the Voting Rights Act.
Before, I have a question for Mr. Cox. This is the moment the hearing broadens beyond the courtroom and into the streets. The question points to protests in Montgomery and Selma, places loaded with civil rights symbolism that is not accidental. Selma immediately evokes John Lewis, the Edmund Pettus Bridge, and the fight that helped produce the Voting Rights Act. The witness is being asked to connect today's legal battle to a historic movement. In other words, this is no longer just a technical discussion. It is a fight over democratic memory.
Central locations for these protests were Montgomery and Selma, Alabama, and both significant sites in American civil rights history. Mr. Cox, can you put this current moment into historical context for us? For instance, why is this moment reminiscent of when the last Congressman, John Lewis, who many of us consider a friend and hero, led over 600 peaceful protesters across the Edmund Pettus Bridge in Selma, Alabama?
Thank you, Senator Hirono, for that question. I think it's reminiscent and reflects the fact that the Voting Rights Act was not given to us. It was not bestowed on us. It really came from the people. And the joke I'm sort of making is that Justice O'Connor used to say there were more lawyers in D.C. than people. I think we sometimes feel that way in D.C. We're on the Hill. Lawyers are at the center of the universe, and that's just not true. If we're going to climb out of this destruction of the Voting Rights Act, the penultimate destruction of our democracy, it's going to require the people. And quite frankly, we're being gaslit. We have a Supreme Court, we have allies of the Supreme Court and allies of the Callais case saying discrimination is over. Obviously not true. We have folks on the ground showing and discussing with us that law enforcement are at the polling places. We have folks not only confused, but being discriminated against right now. And I have to say that to ignore the fact that the people are demanding that Congress respond, that Congress restore the effects test that has been gutted and taken out by Callais would be a mistake. Because folks understand and know what is happening outside in the real world. And they know, particularly black voters know, that they aren't going to return to the 1800s and what we all experienced, or our ancestors experienced, that led us to the Voting Rights Act in the first place.
Just a moment ago, our colleague Senator Hirono said there's a lot more to say, and indeed she's right. And in fact, I want to go back to her comments. She began by saying we have a long history.
Before. Just a moment ago, our colleague Senator Hirono said, now the hearing takes a hard partisan turn. The senator responds to the historical argument by focusing on which political party supported racist voting systems in the past. This is a powerful but risky move. It shifts the focus from institutions and policy effects to party identity and historical blame. For supporters, this sounds like a correction of selective history. For critics, it may feel like a distraction from present-day voting rights consequences. Either way, the tone has clearly changed from legal analysis to political combat.
Of racial discrimination in this country, that's undoubtedly correct. And then she said, quote, we had poll taxes, we had literacy tests, we even had tests of how many jelly beans are in a jar. Mr. Chamberlain, when Senator Hirono says we had poll taxes, I want to ask you who we is, and in particular, what party was it that implemented poll taxes in the South?
I mean, I don't want to necessarily speak in every single case, but I'm pretty confident it was mostly the Democrats.
And what party was it that put literacy tests in place in the South?
Same answer, mostly the Democrats.
And what party was it that had tests like how many jelly beans are in a bottle?
The Democrats.
Tell me, what party were the founders of the Ku Klux Klan from?
I'm pretty sure that was the Democrats.
Indeed. In fact, Nathan Bedford Forrest, the founder of the Klan, was a delegate to the 1860 Democrat National Convention. What party wrote the Jim Crow laws in the South?
The Democrats.
And so on this side of the aisle were members of the Republican Party. Who was the first Republican president?
Abraham Lincoln.
The Republican Party was literally founded to oppose slavery. We came into existence because slavery was a grotesque evil And it was President Lincoln, the first Republican president who signed the Emancipation Proclamation, who won the Civil War, and that resulted in the freeing of the slaves and the passage of the 13th, 14th, and 15th Amendments. By the way, fast forward to the Civil Rights era. Bull Connor, one of the most noxiously racist politicians, what party was he from?
He was a Democrat.
The Democrats, for the entire history of their party, have been a party based on racial discrimination. They affirmatively embrace it. They support it. Let me ask you, Mr. Grime, is discriminating based on race consistent with the United States Constitution?
No.
What does the 14th Amendment say about discrimination based on race?
It's prohibited.
What does the 15th Amendment say about discriminating based on race, and in particular drawing congressional lines and explicitly discriminating based on race?
It's prohibited.
Now, the Democrats are fond of telling this story that is, and I wish I could find a kinder way to say it, a flat-out lie. That without discriminating based on race, that no African Americans will be elected and no Hispanics will be elected. Indeed, there was one fellow online who was a vocal left-wing spokesperson who tweeted out, "If I'm advising anybody to run for president, they sure as hell better have a solution to how you make sure that it's not another 100 years before another black person can represent South Carolina." So that's a typical Democrat statement, that we cannot elect a black person in South Carolina without discriminating based on race. I want to ask you, Mr. Chamberlain, who is the junior senator from South Carolina right now?
That would be Tim Scott.
And, all right, I'll tell you what I said online. I said, hey, Grok, who is Tim Scott? And why do Democrats think he isn't black? And by the...
After no, he won statewide. This is the senator's counterexample strategy. By naming black and Hispanic Republican elected officials who won in majority white or statewide districts, he is challenging the idea that minority candidates require race-conscious districting to win. It is a dramatic point because it turns representation into a debate over ideology, party loyalty, and voter assumptions. But the deeper question remains unresolved. Do individual examples prove the system is fair, or can broader patterns still show barriers for minority communities?
By the way, was Tim Scott elected because of a gerrymandered district drawn only to elect an African American?
No, he won statewide.
He won statewide. By the way, the Democrat position is you can only elect African Americans with a gerrymandered district. I will point out Burgess Owens, an African American, is elected in a majority white district in the state of Utah. He's a Republican. Byron Donalds, another African American, is elected in a majority white district in Florida. He is a Republican. John James, another African American, is elected in a majority white district in Michigan. He is a Republican. And my own congressman, Wesley Hunt, who represents me in the House of Representatives, he is elected in a majority white district. He is a Republican. And yet, in the Democrats' world, you're not black if you're not a liberal Democrat. There is an arrogance to African American voters. By the way, they also have that same arrogance to Hispanic voters. They say you're not Hispanic if you're not a liberal Democrat. Well, I'll tell you, I am proud to be the first Hispanic ever elected to represent the state of Texas in the United States Senate. And Mr. Chamberlain, in my election in Texas, was I elected in a gerrymandered district that could only elect an Hispanic?
No, you were elected statewide.
Discrimination based on race is wrong. Final question. The Democrats are now clutching their pearls that seats drawn to elect liberal Democrats in the South are going to go away. You may get black Republicans instead. Indeed, in Tennessee, they're freaking out that a liberal white guy who's a Democrat is likely going to lose his seat to an African-American woman who's a Republican, and they say that's horrible racial oppression. My final question is this. If you look nationwide, Which party has egregiously abused gerrymandering for decades? Both parties are guilty of it, but who has been the worst offender? And in particular, take New England. Take Massachusetts, take Connecticut, take Rhode Island, take Maine, take Vermont, take New Hampshire. How many Republicans are elected from all of New England in the House of Representatives?
I think the answer to that is zero.
Zero. They've drawn every district in a naked gerrymander, and yet they're very upset that their illegal pursuit of power has now been stopped by the Supreme Court that is enforcing the Constitution and prohibiting the racial gerrymandering and discrimination their party is built on.
Mr.
Senator
Chairman?
Padilla.
Just a
Mr. Chairman, part of personal privilege.
Sure.
I feel personally aggrieved to sit here and to be lectured by my colleague from Texas. And this reminds me of the time when he was first elected to the Senate, and the Judiciary Committee had a hearing on gun safety, and he felt a need to lecture Dianne Feinstein, who was a leader on gun safety legislation, and he took that opportunity to lecture Dianne Feinstein about gun safety and her leadership on the issue. And she said to him something along the lines of, I did not sit here on this committee for however many years she did, only to be lectured by you, and that is how I feel. So why don't you just stop lecturing the rest of us? Just because you think you are the smartest person in the world doesn't mean the rest of us agree to that, okay? Thank you.
Senator Hirono,
Senator,
I knew
Senator.
Dianne Feinstein. I served with Dianne Feinstein, and you're not Dianne Feinstein.
All right, Senator Padilla. We're done. Senator.
For more content like this, stay tuned to Congress Clips, and thanks for watching.
For more content like this, stay tuned to Congress Clips. What we just watched was not a quiet legal hearing. It was a high-stakes political clash over voting rights, race, party power, and the authority of the Supreme Court. One side framed the court decision as a return to constitutional limits. The other side framed it as another blow to hard-won civil rights protections. Along the way, the debate moved from legal standards to California maps, partisan gerrymandering, voter registration rules, Selma, Jim Crow, party history, and finally a personal confrontation between senators. The biggest takeaway is this: voting rules are never just paperwork. They shape power, representation, and public trust. Was this a serious constitutional debate, or did it become political theater? If you found this political breakdown as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real-life political commentary and analysis.